This hearing on the Committee on the Judiciary, Subcommittee on Commercial and Administrative Law will now come to order. Without objection, the Chair will be authorized to declare a recess of the hearing. I will now recognize myself for a short statement. Within the last year, we have seen an increase in foreclosures and job losses and a drop in value of retirement accounts. Several congressional committees have held hearings to determine what caused the economic downturn and what impact the downturn has had on consumers, workers, and businesses. This subcommittee recently held a hearing to examine whether the credit card industry's practices are bankrupting Americans. We heard testimony from witnesses that excessive fees and interest rates, unilateral change in term provisions, and changes in credit limits have exacerbated the burden borne by credit card debtors. The growing burden, we learned, has pushed some debtors into bankruptcy. Just last week, Congress passed the Credit Card Holders Bill of Rights Act in an attempt to shield cardholders from some of the most outrageous practices of the credit card industry. Some of these practices have hindered some cardholders' ability to weather this downturn. Today's hearing will focus on arbitration and how its use has impacted consumers, specifically credit card holders. Nearly every credit card issuer includes an arbitration agreement in the terms of use of contracts with cardholders. Arbitration agreements were initially used to free up the courts from an increasingly heavy docket and to allow quicker resolution to the dispute. However, the use of arbitration has expanded from simply involving disputes between commercial parties to issues between consumers and businesses, employees and employers, and shareholders and corporations. As arbitration has increased in popularity, what was once a choice has become a mandatory, more or less adhesion part of a consumer contract. In effect, according to the 2004 survey, 1/3 of all major consumer transactions are covered by mandatory arbitration clauses. And despite all of the benefits of arbitration, mandatory arbitration agreements may not always be in the best interest of the consumer. This hearing will provide members of the subcommittee the opportunity to hear testimony about the credit card industry's use of arbitration to resolve disputes with cardholders. We'll hear from some witnesses who will speak in favor and some who will speak against. We will also hear testimony about studies which analyzed arbitration decisions concerning credit card disputes and how those decisions impact the credit card holder. And members will consider whether the inclusion of arbitration clauses is beneficial to the credit card holders, or do these clauses simply place an additional burden on the card holders, many of whom are barely keeping up with mortgage or rent payments, insurance premiums, and credit card bills. So today's testimony and hearing is quite relevant to the distress that many in America are experiencing. Accordingly, I look forward to hearing today's testimony, and I now recognize my colleague from Arizona, Mr. Franks, the distinguished ranking member of the subcommittee, for his opening remarks.
Well, thank you, Mr. Chairman, and thank you for calling the hearing. Arbitration is indeed an important topic. We examined it more than once in the 110th Congress, and I would confess that my working conclusion from those hearings is that the theory and evidence both show that arbitration is working well for consumers and that our overburdened court system needs the arbitration system as a vital relief valve. And I therefore am of the view that if we're going to even consider doing anything to reform the arbitration system this term, including with regard to credit card arbitration, we need to do more oversight and ask more questions about whether that is truly needed. The issue of credit cards and arbitration is a good example of our need for more information. We last considered this specific issue in June of 2007 during our initial hearing on mandatory binding arbitration. At the end of our hearing, there were numerous important open questions. We were able to consider only some of those that might bear on whether reform on the system makes sense. The first set of questions was about what really is happening in consumer cases that go to mandatory binding arbitration. Are consumers doing well there compared to litigation? Do they receive a fair process? Do they receive timely results? Do they face excessive costs? Are they satisfied with the process, with the system and the outcome? If there are shortcomings in these areas, are there things we can do to improve mandatory arbitration rather than to just eliminate it? A second set of questions concern voluntary arbitration. If we restrict mandatory binding arbitration, will consumers and businesses be able to use it instead of litigation? Or instead, will one side or the other inevitably see that litigation gives it the upper hand in such cases if a dispute arises, leading requests for voluntary arbitration to fall on deaf ears? And will the parties who have had the advantage in litigation usually be the businesses, which typically have time and money on their side? Another important set of questions concern that very alternative to arbitration, which is, of course, litigation, particularly class action litigation. For example, can litigation possibly compete with arbitration in its ability to deliver at least some reasonable justice promptly? Will litigation attorneys even take the small money, small fee cases that make up so much of the caseload in arbitration? And if they don't, won't that leave millions of working poor Americans with no recourse to justice at all? More pointedly, with regard to class actions, does the history of class actions in producing per plaintiff awards that are they're little more than peanuts give us any confidence that class actions pave a better path to justice than arbitration? And what does the class action corruption revealed by the Milberg-Weiss scandal tell us? This is where, Mr. Chairman, where prominent class action lawyers were convicted for essentially buying and selling fake evidence and witnesses in class actions. Shouldn't we investigate the corruption of the class action system to the bottom before we hand another huge portion of this country's disputes over to the class action plaintiffs' bar? I could go on, Mr. Chairman, but I suspect that you see the point. There are many, many questions that we must ask, both about arbitration and litigation, before we can reasonably entertain proposals to expand the litigation system at the expense of the arbitration system. And of course, I'm, as always, eager to hear more information today. I expect that much of that will confirm our already strong reasons to believe that arbitration is often better for consumers and certainly typically no worse than litigation. And I reserve the balance of my time, it says here, Mr. Chairman.
So reserved. I thank the gentleman for his statement. I now recognize the distinguished subcommittee chairman from the great state of Georgia, Mr. Hank Johnson, distinguished member of the subcommittee, for an opening statement.
Thank you, Mr. Chairman, and it's always a pleasure to come back and learn so much from yourself. I've been sitting at your knee for a long time and listening carefully. So
you have 7 minutes.
All right, okay. And I hope you'll continue to allow me to gain some experience, Mr. Chairman. And ladies and gentlemen, you know, the Federal Arbitration Act is the credit card industry using the act to slam shut the courthouse door for users. That's our topic today. And Mr. Chairman, forced arbitration has been a concern of mine for some time, and I firmly believe that Congress must act in this instance to protect consumers. Credit card users are certainly subject to forced arbitration, as are employees, cell phone users, and franchisees. My legislation, H.R. 1020, the Arbitration Act of 2009, seeks to correct this unfair practice where consumers are forced to sign pre-dispute mandatory arbitration clauses. And in the last Congress, we had 103 co-sponsors of the bill. This time, we've got almost 60. One of our indelible rights is the right to a jury trial. Guaranteed by the United States Constitution, this right has been gradually eroded through forced arbitration agreements. Just by taking a job or buying a product or service, individuals are required to give up their right to go to court. And if they believe that they are harmed by the company. According to a recent study, roughly 3/4 of Americans incorrectly believe they can sue an employer or company should they be harmed or have a major dispute that arises, even when they are bound by forced arbitration. Businesses defend these forced arbitration agreements by arguing that it's cheaper, more informal, and results expedited process is the result. But these agreements leave consumers, employees, and small businesses at a distinct disadvantage. However, the Arbitration Fairness Act does not forbid arbitration clauses. It merely prevents forced pre-dispute arbitration clauses. Consumers may still opt to arbitrate a dispute with a company, but only when that consumer determines that it is the appropriate forum at the time the conflict arises, and certainly not before. Forced arbitration appears fair on its face. What could be wrong with being judged by a neutral arbitrator picked by both sides? That's only half the story, though, ladies and gentlemen. Arbitrators tend to favor what we call repeat players. These are the people who impose the pre-dispute mandatory arbitration on consumers. And so it's not the consumers that refer the business to these arbitrators, it's the businesses. And so they tend to be predisposed, of course, to serve the one that pays them. And that's only human nature. Arbitration is also expensive, and individuals still must pay exorbitant legal fees for the ability to go into an arbitration process which is stacked against them. These arbitration proceedings may be called 4,000 or 5,000 miles away from where you live or where the dispute arose. You've got to pay for travel expenses going out there, hotel expenses. Arbitration can also be difficult for individuals to navigate, so oftentimes you do need an attorney. And by the way, the corporate attorneys get paid by the hour. And so I think we should have tort reform with respect to the hourly fees that are charged by these warriors for commercial interests. And I certainly have no problem with lawyers. I'm a lawyer myself, and some of my best friends are lawyers. And lawyers on both sides, by the way, defense and plaintiffs. Importantly, I guess most importantly, Americans are not even aware that they are signing these clauses because they are written in legalese and buried in fine print. Mr. Chairman, once again, thank you for holding this hearing, and I'll yield back.
Thank you, Mr. Johnson. Is there somebody on this side that would like to make an opening statement? I recognize the distinguished gentleman from the Alamo, San Antonio.
Thank you.
Ranking member of the full committee, Mr. Lamar Smith.
Thank you, Mr. Chairman. Let me confess at the outset to having a little bit of a vested interest in this subject today. Long ago and far away, when I was a county commissioner in San Antonio, Texas, the city of the Alamo, I started the Bexar County Mediation Center, and it has grown and prospered and is considered a real success. So I do believe in that concept to a great extent. Mr. Chairman, arbitration is vital to this nation's dispute resolution system. Consistent with fundamental American values, it is fair, low cost, and easily accessible. It is a beneficial addition to our civil courts, which are overburdened, understaffed, and clogged with abusive lawsuits. Further, unlike litigation, it tends to avoid rather than hasten the destruction of commercial relationships. Advocates of more litigation, particularly the plaintiff's class action bar, have long sought to eliminate arbitration. Theirs is largely an effort to stamp out the competition that arbitration poses to litigation attorneys. Today's hearing might also be called a hearing on efforts to void the Federal Arbitration Act, our trial lawyers trying to stifle competition. I hope that's not the case, but bills are pending in Congress to wipe out large areas of arbitration. They are backed by the plaintiff's trial bar, and they are contrary to the clear and growing evidence that consumer arbitration works, is fair, and should be preserved. Not only that, there is growing evidence that arbitration works better than litigation. One of the witnesses at today's hearing, for example, has just released an important, nonpartisan, peer-reviewed study on consumer arbitration. That study, Consumer Arbitration Before the American Arbitration Association, confirms that arbitration works and works fast for the consumer. It produces mutual settlements or voluntary dismissals in a large share of cases. Consumers win relief in most cases they file. There is no proof that companies are favored over consumers. Arbitration provides a predictable and low-cost alternative to litigation, particularly class action litigation with its runaway jury awards. That, in turn, lowers the cost of goods and services. And in this economy, what consumers need are lower-cost goods and services, not class action lawyers. In the credit card sector, lower-cost goods and services means more accessible consumer credit at lower interest rates. We should do everything we can to preserve what makes credit cheaper and more available in today's economy. President Obama, less than 2 weeks ago, highlighted the urgent need to make more consumer credit available. He also urged credit card companies to make their contract terms more understandable and more transparent. And he expressed support for curbing some credit card practices alleged to be abusive. But he did not identify credit card arbitration as an abusive practice, nor did he make any suggestion that we should prohibit it. The preservation of arbitration is consistent with sound economic principles and traditional American values of freedom of contract and self-reliance. If we act contrary to these principles and values, who will benefit? Consumers will not benefit. They will lose access to both a fair means of dispute resolution and cheaper credit. The court system will not benefit. It will be overloaded with cases that arbitrators can resolve more rapidly and less expensively. Taxpayers will not benefit. They will have to shoulder the burden of the court system's increased demand for resources. Not even plaintiffs in the new and unnecessary litigation that trial lawyers seek will benefit in the end. It will take longer for them to recover remedies. Their relationships with good companies too often will be sacrificed, and the class actions that anti-arbitration interests promote too often pay pittance in damages or nothing at all. So who will benefit? Mainly it will be class action plaintiffs' lawyers who squeeze millions of dollars in fees from their clients' cases. Let's not let today's hearing mark the day we began to throw another log on that fire of citizen outrage by sacrificing our arbitration system to the special interest of trial lawyers. Mr. Chairman, you've been very gracious with the time, and now I yield back.
Thank you, Mr. Smith. I appreciate your statement. Now I'd like to recognize a distinguished first-year member from the state of New York, unlike Mr. Johnson, not a lawyer, but a holder of a credit card, Mr. Maffei.
Thank you, Mr. Chairman, though I must point out to you, I cut up my credit card on the floor of the House last week, so. Actually, I do have two now. I have two. My wife wants me to cut up the other one as well. I commend you for holding this hearing, and I do want to thank the witnesses for being here today. And I want to be clear that I do not oppose the concept of arbitration. Indeed, Mr. Smith just brought up some very good points. And when used appropriately, arbitration can be an extremely useful and effective tool, as it offers an avenue to settle cases much quicker and at a lower cost. However, we do not currently have a level playing field right now, and we must be here and do this kind of hearing to address some of these problems. The credit card industry, in my view, is one example where businesses have understood the benefits of arbitration and have nearly uniformly included binding arbitration agreements in their contracts. Unfortunately, many have gone beyond the congressional intent of the Federal Arbitration Act and abused the system, effectively tilting the scales of justice unfairly in their favor. As an example, I'd like to tell the story of Anastasia Komarova, a constituent of mine who was wrongfully hurt by forced arbitration. In February of 2005, she started getting phone calls from debt collectors about delinquent credit card balance. But what's strange is that she did not even have a card with that company. In fact, when the card was issued, she hadn't owned any credit cards at all. It turned out that the credit card company had the wrong Anastasia, who spelled her name a little differently. The debt collector continued to pursue the issue, and she was asked to appear before a private arbitrator in Minnesota. And Anastasia tried to convince the debt collector that they were targeting the wrong person, but they did not seem to care. And a judgment of over $11,000 was made in favor of the company in this case. This judgment immediately became enforceable in court, even without Anastasia having a chance to defend herself. Under the Federal Arbitration Act, a court would not be able to re-examine the decision, even though it was clear that she was a victim of mistaken identity or perhaps even identity theft. So this hearing comes on the heels of the credit card holders' Bill of Rights. For far too long, the scales have been tilted in the direction of the companies. This, in my opinion, is in large part due to the ridiculously broad contract that virtually all credit card issuers issue that include these arbitration clauses. Indeed, very few of us can say we understand our credit card agreements, and those of us that can say usually understand that they give almost all of the power to the issuers. I do believe that it's appropriate to have a lawyer when you're buying a house, when you're purchasing a house, but none of us who are not lawyers should need a lawyer there just to get a credit card. Arbitration was intended to improve access to justice, and we should work to keep it that way and not make it yet another tool to collect money from consumers like Mrs. Komarov. I look forward to the testimony from our panel, and I thank the chairman for holding this important hearing, and I yield back the balance of my time.
Thank you. Appreciate your statement. And without objection, the rules of the subcommittee are in place that all members who make opening statements have to stay for the entire hearing. Without objection, that's done. I now recognize Mr. Coble for an opening statement.
Thank you, Mr. Chairman. I'll be very brief. Thank you for calling this hearing. Mr. Chairman and colleagues, one criticism that has been brought to my attention alleges that arbitrations are biased. And I'd like to hear from the witnesses if they are aware of any study or empirical data that would confirm or reject the notion that only arbitrators favorable to the credit card industry oversee these cases on the one hand, or conversely, whether arbitrators favorable to credit card holders or consumers oversee these cases. And with that, Mr. Chairman, I yield back the balance of my time.
Thank you, Mr. Coble. Sorry. Is there anybody else on the Democratic side who would like to make an opening statement? If not, anybody on the Mr. Issa is recognized. California, the Golden State.
Thank you, Mr. Chairman. And I, too, am both not a lawyer and have a credit card. But unlike some people, perhaps, I've also been on both sides of arbitration. Arbitration's gotten it right, and then also I've lost. We'll consider those when arbitration got it wrong. But I am an advocate for arbitration. But more importantly, here today, I hope to hear from the witnesses how, in fact, we on the dais seem to have the hubris, and those in the White House seem to have the hubris, to believe that we can overturn 200 years of contract precedent. That, in fact, what we're talking about here today is depriving an arm's-length relationship between somebody who will extend money to someone with virtually no collateral, or no collateral in most cases, in return for simply a promise that they will pay it back under the terms that they're offered. In addition to being a credit card holder, I'm the former CEO of a company that expanded our sales by huge amounts based on the reliance on credit card companies. Many of my customers, although all businesses, use their credit cards to expand their credit, sometimes as much as $100,000 in credit cards that they would run up in purchases of my company's products. I signed a contract. I didn't like the contract because the contract left the credit card holder in a position where they could dispute a bill and I would be immediately debited back. Ultimately, we had a system of arbitration if we felt that was unjust, but in fact, that was part of the deal. We accepted that because it expanded our business, and we did so voluntarily and entered into the many contracts. My companies that bought my products entered into their contracts. What we're talking about here today is preempting the ability for companies to offer a contract and individuals to choose that contract. We do so at our peril, just as I believe the preemption of bankruptcy in the Chrysler case and a great many other things today cause people around the world to question whether we are in fact a constitutional republic where the rule of law is predictable, or whether or not we will simply from time to time, for convenience, intervene with contracts long-standing. With that, I yield back.
Thank you, Mr. Issa. If there are no other members seeking to make an opening statement, they may submit a statement to be entered into the record. I'm now pleased to introduce the witnesses and hear their testimony for today's hearing. Thank you all for participating in today's hearing. Without objection, your written statements will be placed in the record, and we would ask that you limit your oral remarks to 5 minutes. You'll note we have a lighting system here, red it's the end. Yellow, you got a minute to go, and green, you're on your own for 4 minutes. After each witness has presented his or her testimony, subcommittee members will be permitted to ask questions, also subject to that 5-minute limitation. Our first witness is Michael Donovan. Mr. Donovan is a founding member of the law firm Donovan Searles. Following graduation from Vermont Law School, Mr. Donovan was a trial attorney with the SEC in Washington, prosecuted numerous securities cases and enforcement matters, including injunctive and disciplinary actions against public companies, broker-dealers, and accounting firms. He's co-authored many publications, including Preserving Judicial Recourse for Consumers, How to Combat Overreaching Arbitration Clauses. Mr. Donovan has appeared as a faculty member and speaker at the ABA's Class Action Forum, the Consumer Credit Regulation Forum of the New Jersey Bar, the National Consumer Rights Litigation Conference sponsored by the National Consumer Law Center. He's a member of the ABA and the chair of the Consumer Law Subcommittee of the ABA Litigation Section's Class Action and Derivative Suit Subcommittee. He's also the former vice chair of the National Association of Consumer Advocates and an active member of the Trial Lawyers for Public Justice. And I guess all that makes you a plaintiff's class action lawyer. Thank you, Mr. Donovan. You begin your testimony. You need to press a button, I guess. Is that the button? And you need to turn on the clock.
Okay. Is that better? Check, check.
We're good.
Let me start by answering directly the question presented by the title for this subcommittee hearing. Yes, the credit card industry is using forced arbitration and the Federal Arbitration Act to quash legal claims by ordinary consumers that are in each of your districts. Congress must pass the Arbitration Fairness Act, sponsored by Congressman Johnson, in order to stop the misuse of federal law to deny the due process rights of my clients and every one of the American citizens represented by this panel. In 2007, I appeared before the Senate Banking Committee to discuss the problems with the credit card industry. I described the many abuses imposed upon my clients and your constituents by the unfair practices of the credit card industry. Let me point out, Congressman Issa, that the one difference between the credit card contract and 200 years of contract law in this country is that the credit card contract, unlike any other common law contract with which we are familiar, includes a unilateral change in terms provision that allows the stronger party, the party with more power, to unilaterally change the terms of that contract at any time for any reason to impose any penalty, charge, fee, or term that it wants. And the credit card companies have used this abusive change in terms provision over and over and over again. No other contract in American history has ever included that type of unilateral change in terms provision without notice. And the card companies are using those provisions today to impose unfair penalty rates, tripwire pricing, tricks, traps, reverse promotional offers, undermine promotional offers, and yes, indeed, to impose unfair arbitration clauses in which they can sue and have sued my clients in distant fora. In fact, most of the credit card industry now uses an arbitration forum that is in fact biased. It is biased because we know from arbitrators who have worked for this forum that it is a biased forum. The name of the forum is the National Arbitration Forum. It is located in Minnesota, and it frequently conducts unfair, on-the-paper arbitrations in which it enters judgment unilaterally against consumers, as Mr. Maffei's constituent experienced. That forum unilaterally entered a mistaken arbitration award against his constituent when, in fact, that constituent never even had a contract allowing that forum to perform arbitration. Now, is that a unique experience? Does that happen rarely, infrequently? It happens every day. The websites are littered with tens of thousands, hundreds of thousands of complaints about credit card practices, abuses, deceptive misconduct. Let me start with an example. One example is the notorious In Re Providian Bank. Its credit card portfolio was purchased by Washington Mutual. It's now owned in part by J.P. Morgan Chase. What did Providian Bank do? Well, Providian Bank was the target of a class action litigation. Yes, I was involved in the class action litigation. And guess what the class action litigators found in litigating this frivolous case? The reality of it is what they found was that Providian Bank had embedded in the barcodes of its return payment envelopes, those barcodes on the bottom that you send your check in with, intentionally embedded the wrong zip code in order to ensure that the payments cardholders sent in would be late, so that Providian could increase its late fee revenues. That's what the class action lawyers found. And Providian Bank, the reason why they did that was because Providian had already sold off its rights to the interest that people would pay on those credit card receivables. But for the late fees, Providian got to keep those as revenues and could report them to their shareholders as higher revenues. So this is what the class action lawyers found, was that this conscious deceit, fraud, deception was performed by Providian on its own cardholders. Why did it perform this? To increase its revenue, inflate its stock price, and award higher bonuses to all these Wall Street titans. That's what Providian did. What happened in the Providian case? Well, the class action was settled for $105 million. Yes, on a per member basis, is that a lot of money? Do people only get back $30? Sure, they only get back $30 because that's how much they were overcharged. That was the late fee. They also had to pay penalties because the OCC, their regulator, came in late. The OCC has been an abomination. They do not regulate banks. They are owned by the banks. In fact, the banks pay almost all of their budget. In fact, people choose to. I'm over my time. I'm sorry.
Mr. Donovan, somehow or another, you didn't get to go to yellow. And so what we'll do is split the difference and give you 30 seconds.
Very good.
Yeah.
And I apologize, Congressman. It's my temptation as a trial lawyer to call just about everybody Your Honor. So if you'll permit me that informality.
You're down to 17 seconds.
In any case, the fact of the matter is in the absence of class actions for these small value claims in which consumers cannot ever gain access to court, you will have tens of thousands of credit card companies continuing to engage in massively abusive practices, which everyone in the United States knows is ongoing and will continue to be ongoing, particularly with arbitration. Thank you.
Thank you, Mr. Donovan. I appreciate your testimony and your appellation. Our second witness is Richard Frankel. Professor Frankel teaches at Drexel University School of Law, and his chief scholarly interests include consumer, administrative, and immigration law. He served as a teaching fellow and supervising attorney for the Georgetown University Law Center's appellate litigation program. While there, he supervised students litigating before the U.S. Court of Appeals for the D.C. Circuit, the 4th and 9th Circuits, as well as the Board of Immigration Appeals. Professor Franken's clinical interests include consumer law, appellate advocacy, landlord-tenant law, immigration law, public benefits, civil rights, and prisoners' rights. Previously, he was a Goldberg-Deitzler Fellow for Trial Lawyers for Public Justice in Washington, D.C., where he litigated class action, consumer protection, and civil rights cases. Thank you, Professor Frankel. Will you begin your testimony?
Thank you. Honorable members of the committee, thank you for the opportunity to participate in this hearing. As several of the members of the committee mentioned, there has been a lot of debate about empirical evidence either for or against arbitration and about whether consumers fare better in arbitration than they do in court. But what I would like to focus on today are problems that exist with arbitration that exist, the public consequences of giving up your right to a jury trial, problems that exist irrespective of the specific outcomes for the private parties in the process. And specifically, the closed nature of the arbitration process relative to court and the expansive reach of federal preemption that prevents states from regulating arbitration clauses in the way that they're permitted to regulate any other contract mean that no matter who benefits from arbitration, the public and society at large will suffer. In particular, arbitration prevents the law as a whole from developing, growing, and adequately keeping up with changing circumstances. And this is a particular problem in the credit card sector precisely because arbitration clauses are so universally used in that area. That essentially allows an entire area of consumer protection law to be removed from public scrutiny by the use of adhesion contracts, take it or leave it, arbitration clauses. Arbitration hearings, unlike judicial hearings, are private matters. Arbitrators have no obligation to provide a written decision explaining how they reached their decision or to provide reasons justifying that decision. In fact, arbitrators have an incentive to write as little as possible in order to insulate their decisions from being overturned by courts. Arbitrator decisions do not create precedent. They're not binding on anyone, including the arbitrator, who's free to disregard his or her own earlier decisions in later cases. And some arbitration providers even require the parties to keep proceedings confidential. This prevents the law from taking shape in the way that it normally does. Judicial opinions, public, written, well-reasoned decisions play a crucial role in adapting the law to changing circumstances. They give notice to parties, they explain the meaning of the law to the public, they make the legal system transparent to the public at large, and they promote deterrence by informing individuals of their rights and responsibilities under the law. Without written decisions that create this kind of precedent, the law stagnates and stays in a position essentially of suspended animation. And this is true both not just for private law, but for public law as well. Even statutes, important public statutes like Title VII, our Civil Rights Act, the Truth in Lending Act, all of these are essentially removed from an ability for courts to give reasoned decisions explaining what those laws mean when they are removed and put in a system of private arbitration. Now, the Honorable Congressman Franks called for a need for more information, and I wholeheartedly agree. And I think one of the problems with arbitration is that it's so private that we don't get the kind of information that we need in order to make informed decisions, in order to know that our justice system is working, in order to inspire public confidence in the way things work. Many arbitration providers, the ones who hold data, won't even release the data that they have unless they're required to by state law. Now, I think all of these potential problems with arbitration are exacerbated by a lack of meaningful opportunity for review of arbitrator decisions. Closed proceedings might be a little less problematic if the public had confidence that they could be reviewed for error, but the Federal Arbitration Law Act prohibits that from taking place. Review of arbitration decisions has been called by courts as one of the narrowest forms of judicial review that exists, and courts have said even that when an arbitrator's findings are wacky or silly or based on evidence outside the record or based on gross errors of law, those findings will not be overturned. Given all of these things, how or why the public should have any confidence in a system that's closed from public view, that involves decision makers who don't have to explain how they reach a decision, and that makes those decisions immune from review is beyond me. Public confidence in any judicial system, arbitral or a public system, is important in making it legitimate, and there's no reason for the public to have any confidence in the system. Now, the last significant problem with arbitration that I would like to address is the inability of states to take action to try and protect their citizens from the abuses of arbitration. Congressman Issa talked about the hubris of why should Congress act to overturn 200 years of contract law, but the hubris really is in the current preemptive reach of the Federal Arbitration Act, which precludes state legislatures from democratically enacting legislation that protects their citizens from the worst abuses of arbitration clauses. All of those are preempted by the Federal Arbitration Act. Thank you.
Thank you, Professor. Our third witness is Christopher Drahozal. Professor Drahozal. Drahozal?
I've heard it any way you can come up with.
Which is the way you prefer?
Drahozal's the better.
Drahozal. Professor Drahozal teaches at the University of Kansas, which Memphis gave a national championship to 2 years ago, and is an internationally known scholar whose writing focuses on the law and economics of dispute resolution, particularly arbitration. He's the author of multiple books and numerous articles on commercial arbitration and has taught and given presentations on the subject in Europe and the USA, serving as an associate reporter for the ALI's restatement of the U.S. law of international commercial arbitration. Prior to coming to Kansas, the professor practiced law with Sidley in Austin and D.C. and served as a law clerk for Justice Byron R. White of the United States Supreme Court and Judge George H. Aldrich of the Iran United States Claims Tribunal in The Hague, the Netherlands. Thank you, Professor Drahozal. Will you please proceed with your testimony?
Thank you, Chairman Cohen, Ranking Member Franks, members of the subcommittee. I really appreciate the opportunity to be here today. I did not wear my Jayhawk tie in deference. I've been very pleased with the discussion so far, with sort of the interest in empirical work, because from my perspective, I think sound empirical evidence is really essential for making good public policy. And in the arbitration area, actually, one commentator recently found, quote, a consensus that the future of arbitration should be decided by data, not anecdote. The Searle study, which I'm the chair of the Consumer Arbitration Task Force of the Searle Civil Justice Institute, is the most recent and frankly the most comprehensive look at consumer arbitration as here administered by the American Arbitration Association. A few sort of background points on the Searle study. First of all, there's absolutely no industry funding whatsoever for this study. It was funded exclusively by the initial grant of money to set up the Searle Center to Northwestern Law School by the late Daniel Searle, a Northwestern trustee. I would frankly have made a condition of my participation in the study that they not use industry money, and that was never an issue because that was never the plan. So no industry funding whatsoever in this study. Searle Civil Justice Institute follows a rigorous research protocol governing how we do our work. The report itself, as was mentioned previously, was peer-reviewed by an array of scholars on arbitration law and empirical work on arbitration law, and I mean, frankly, from across the ideological perspective, from supporters and critics of consumer arbitration. We're very comfortable with the methodology of the study. Obviously, our results focusing on the American Arbitration Association are limited to the AAA, as we make clear in the report. Nonetheless, in deciding national policy on arbitration, it seems to me that what is done by the oldest and most prominent arbitration association in the country certainly is relevant and important to that debate. Our study does not focus exclusively on credit card disputes, but certainly includes a significant number of credit card disputes and more broadly debt collection disputes in our sample. A couple of highlights from the study, and there's a lengthy study, plenty to say, but I'll just make a couple points at this stage. First, the vast majority of the arbitrations in that study arose out of pre-dispute clauses, over 96%. Only a handful of cases arose out of post-dispute clauses. That result is actually consistent with every other study that I have seen looking at employment arbitration, and sort of interestingly, international arbitration is the same way. The vast majority of disputes arise out of pre-dispute clauses. The standard advice in drafting, and the reason I mention international arbitration is there's no question that there you have sophisticated parties on both sides, no concerns about the fairness of the process, and yet even in that setting, if you don't have a pre-dispute clause, you don't end up with arbitration. The implications of sort of the finding in the consumer setting and in the international setting, to me, are first, that if you get rid of pre-dispute clauses, it's essentially going to get rid of consumer arbitration. Okay. And second, the reason is not because of some unfairness in the consumer arbitration process, because that rationale wouldn't apply in the international arbitration process. The reason is because once a dispute arises, parties' interests and perspectives change. And once you have a dispute, somebody's going to benefit from going to court, somebody's not, and at that point they can't reach an agreement. No reflection on the unfairness of the arbitration process, but allowing a pre-dispute clause enables parties to enter into agreements that make them both better off they otherwise couldn't enter into. Second highlight in my final minute, my opening statement, is we have a variety of findings in the Searle report. One that people have tended to be interested in is how the cases come out. What we found is that consumers win some relief in roughly 53% of the cases in which they bring claims, and they're awarded just under $20,000 on average. Businesses win some relief in roughly 83% of the cases they bring and are awarded just over $20,000. The fact that businesses prevail more often does not show that there's any unfairness in the arbitration process. To the contrary, what's likely the case is that businesses bring different claims than consumers bring. The business claimants were very different parties than the business respondents. Business claimants tend to be people who provided, or businesses that have provided services and are now collecting debts. Consumer claimants tend to bring claims against businesses that have provided allegedly a defective product in some way, shape, or form. They're harder to prove and they're harder to quantify damages. What that means is you can't just look at outcome numbers to tell whether arbitration is fair or not. So the public citizen studies, which are very interesting, you can't evaluate whether a 94% win rate shows arbitration is fair or unfair without having something to compare it to, i.e. how comparable cases come out in court. Thank you very much.
Thank you, Professor Drahozal. Appreciate it. Our final witness is David Arkush. Mr. Arkush is the director of Congress Watch. He joined Public Citizen in January 2008 after working as staff attorney for public justice, where he litigated civil rights, environmental, and consumer cases, primarily in the area of federal preemption of state law, private standing under consumer protection statutes, and binding mandatory arbitration in consumer contracts. Prior to working at public justice, Mr. Arkush taught at the appellate litigation program at Georgetown University Law, served as the Fuchsberg Fellow at Public Citizen Litigation Group, and clerk for the Honorable R. Lanier Anderson III of the U.S. Court of Appeals, 8th Circuit. Before clerking, Mr. Arkush worked for the private public interest firm Adkins, Kelston, and Zavez, and before law school he served as statewide coordinator of Missouri Voters for Fair Elections. Thank you, Mr. Arkush. Will you proceed with your testimony?
Thank you, Mr. Chairman, members of the subcommittee. Forced arbitration in the credit card industry serves three primary functions. First, it allows credit card companies and debt collectors to wring more unfair fees out of consumers, sometimes the consumers who are least able to pay them. Second, it makes it easier for debt collectors to collect on debts when they lack...
You might want to pull your microphone up a little bit. Thank you, sir.
Second, it enables debt collectors to collect on debts when they lack sufficient evidence or even when the debts are unlawful. And third, it provides a shield from accountability for unfair practices. Forced arbitration in the consumer context has nothing to do with providing consumers a faster, cheaper, and fair forum to bring disputes. On the first 2 points, unfair fees and collection, I have a story to tell that illustrates those points. Cheryl Betts of North Carolina missed one payment. She was late for one payment on her Chase credit card. In response, Chase lowered her credit limit from $6,000 to $4,900, charged her extra fees, charged her a penalty interest rate. Those fees and penalty interest soon pushed her over the new credit limit. That spurred a new cycle of fees and penalty interest. She tried to work out a payment plan with Chase but wasn't able to. 2 years later, she received a letter in the mail saying that she was being taken to arbitration. She owed over $6,000, and to her debt had been added $602 in legal fees, over 10% of the debt. She wrote an 11-page response to which the debt collection law firm responded by seeking an adjournment, which indefinitely suspended the arbitration. 4 months later, she wrote another long letter disputing the debt, to which the debt collection firm responded by seeking a 45-day extension. 1 day after the 45-day extension expired and the debt collection firm still had not responded to Ms. Betts' arguments, the NAF arbitrator ruled in the debt collection firm's favor. In sum, in an NAF arbitration, Ms. Betts was first charged extra fees. Second, the debt collection firm never responded to her arguments. Third, the debt collection firm missed its own extended deadline to respond to her arguments. And fourth, the debt collection firm won. This is not a fair process. This is not a process that has anything to do with providing consumers a benefit. The third point, in terms of what arbitration currently does in the credit card industry, is that it is a shield from accountability for unfair practices. Because there are no class actions in credit card arbitrations, that means consumers generally can't bring any claims at all. As Judge Posner famously said, only a lunatic or a fanatic would bring a small claim individually in court. We need class actions if many of these people are to bring cases at all. The evidence bears out that it's too difficult for consumers to bring cases individually in arbitration, because when we at Public Citizen studied 34,000 NAF arbitrations from 2003 to 2007, this is 34,000 arbitrations, only 118 of them were brought by consumers. Forced arbitration is about denying access to justice for consumers. It is not about providing them a fair, efficient, and inexpensive forum. Proponents of arbitration try to show benefits. They have failed to meet their burden of showing that arbitration benefits consumers. We debunked the majority of these studies that have been done last summer in a thorough report. There is a new study from my colleague, right to my right here, Professor Drahozal, again purporting to show that forced arbitration benefits consumers. It suffers from similar flaws to all the studies that have preceded it. First, it's based on AAA arbitrations. AAA is not a major provider of consumer arbitrations. It's not the right place to look if you want to find answers to these questions. Second, the study's own data shows that consumers do worse than businesses. Consumers won 53% of the time and got 52% of what they asked for. Businesses won 83% of the time and got 93% of what they asked for. That means consumers overall got 28% of what they wanted and businesses got 78% of what they wanted. That doesn't look fair at a glance. The study is also missing key data, largely because of timing. We've done a preliminary analysis of cases that they missed. 61,000 cases since 2004, 45,000 come from a single debt collection firm, Midland Credit Management, that came in after this study's data set concluded. In 87% of those cases, AAA awarded exactly the amount that Midland Credit Management sought. The fourth problem is that there's no independent verification of these kinds of numbers that are in the study. The proponents of arbitration have all of the evidence in their hands, and they're afraid to give it up. Instead, we're forced to fight with table scraps of evidence, and we're still winning the fight on this side. This empirical debate, with all due respect, is a bit of a distraction. Common sense says that a system where the arbitrators are competing for the business of one side is not fair to the other.
Thank you, Mr. Arkush. We'll now begin the questioning, and I will begin by recognizing myself for 5 minutes. Mr. Donovan, in your prepared statement for this hearing, you offer several recommendations for Congress to consider to protect credit card holders. One of these is no mandatory arbitration either for consumer claims or for collection against consumers. Why do you suggest that, and how has the credit card industry used mandatory arbitration, which would lead you to this recommendation?
Remember to press the button. 3 reasons I suggest that. First, this Congress has wisely looked at the exact same question with regard to credit extended to our service members. This Congress has wisely determined that for credit extended to our service members, you should outlaw arbitration, because the process as portrayed and exercised with regard to service member credit is unfair, and it's unwise to force service members to go through biased arbitration. This Congress has also looked at the exact same question when it came to car dealers dealing with car manufacturers, franchisees dealing with franchisors. This Congress has looked and said, look, a car dealer is a smaller operation. It's usually a mom and pop, a small business operation, and it cannot defend itself or fight off mammoth car manufacturers who dictate what the terms of the franchise agreement is going to be. So this Congress, wisely, I believe Republicans and Democrats alike, have determined that you should outlaw arbitration between car dealers and car manufacturers. What are the bases of those 2 decisions? The basis of those 2 decisions is that this Congress determined that arbitration is unfair when when the stronger party has an unfair advantage over the weaker party. Arbitration, the second point, arbitration is doubly unfair when you are talking about small claims. The claims involving credit cards are ordinarily claims relating to payment processing practices, late fees, over-limit fees, or a misapplication of payments or an unfair change in terms. Those are generally small cases, generally not in excess of a couple of $100 at most. Almost no consumer can find a lawyer or has any wherewithal or ability to map themselves through an unfamiliar arbitration process. So what you need is a system in which you have lawyers and advocates who are able to weed through the good from the bad cases and bring the good cases and not pursue the bad cases. And what happens is the class action does that. Third reason, merchants. Merchants are also subjected to arbitration clauses. Mr. Issa pointed out that he was a business owner. The business owners here have also been subjected to unfair arbitration clauses. Merchants have agreements with all the credit card issuers. In fact, one of the biggest class action plaintiffs in the biggest credit card class action in the United States was Walmart stores. It was a representative plaintiff in a class action. It brought that class action and settled it for $3 billion. That is a major manufacturer that will now be exposed to unfair arbitration terms foisted upon it by the credit card industry because it's going to be forced to pay unfair merchant fees that can change at any time. So not only do ordinary consumers need the Arbitration Fairness Act to be enacted, but also every entrepreneurial, decent business in the United States needs the Arbitration Fairness Act to be adopted and changed. Thank you.
Thank you, sir. Professor Frankel, are there alternatives to mandatory binding arbitration less than the bill that's under consideration that you think might be offered that would be fair to consumers and businesses both?
One alternative that I think is a good alternative is the one proposed in the Arbitration Fairness Act, which would make post-dispute voluntarily agreed to arbitration where both parties after the dispute decide they want to arbitrate. That is one alternative. That creates an opportunity for greater fairness, for not having specific terms foisted upon it, that really it's a voluntary agreement. And I think there's a big difference, as you can tell from, I think, most companies' own behavior, that they see a big difference between voluntary arbitration and forced arbitration. Most companies that negotiate arm's-length contracts with other companies don't put arbitration clauses into those contracts. Where they do use arbitration clauses is in there where they can have the chance to do it unilaterally against consumers.
Thank you. My time has expired, and I now yield to the ranking member, Mr. Franks, for questions.
Well, thank you, Mr. Chairman. Professor Drahozal, the second phase of the study that you've been working on will specifically examine the relative merits and demerits of arbitration in class actions. That's kind of the bottom line for the specific topic of today's hearing. When do you expect your study to be complete, and what specific questions will you research?
Well, an important part of the second phase will be looking at how our results compare to other sort of comparable cases in the court system. You can't really evaluate whether something is fair on its face simply by looking what happens in arbitration. So what you have to look at is how arbitration compares to other court cases. I was actually doing some preliminary reading on that question, which we have a while to go, unfortunately, before we will have final resolution. And came across a study that found that corporations won 90% of their claims against individuals, and individuals won 50% of their claims against corporations, which looks a lot like our results from arbitration. What was interesting was that was a study of federal court diversity cases, which are large claims not in arbitration, and you get very similar results. Now, we will focus on sort of comparable claims, which typically are smaller claims, but I sort of anticipate finding similar sorts of things. Other aspects of what we will do in the second phase will be, as you say, look at the extent to which class actions are potential substitutes or comparable cases for arbitration claims. Presumably looking at the cases that, as Mr. Arkush pointed out, were after the time period that we were studying in the initial phase. I wish I could promise a date by which that will be done. My dream date is realistically the end of the year. I mean, this is sort of very intense data collection, and then writing. We will have to see. I had the benefit this year of being on sabbatical to do the first phase. I will be back teaching next semester, and we'll have competing demands on my time. That's my hope.
Well, thank you. You know, I suppose just from a common sense perspective, that doesn't surprise me a great deal, you know, that businesses, before they go after one of their customers, they're going to probably want to have a pretty strong case, and that they would win 90% of those doesn't surprise me at all. So what you say makes sense, and I guess my concern is that if we put this where class actions are the main, you know, the main mechanism for solving these things, it's a little like the old statement that, you know, a lot of times lawyers challenge two people to strip for a fight, and then they steal their clothes, and it's a difficult situation to deal with. So let me ask you, How do you answer public citizens' criticism, Mr. Arkush, criticisms there of your study? How do you respond to that? I want to give you an opportunity because he took your name in vain in some pretty significant ways there.
I mean, most of it was sort of fair debate, I would say. I don't feel slandered in any way, shape, or form. The main response, again, is to some extent the one I just gave, which is, well, I guess first of all, it seems to me the AAA results, while I agree that is one provider out of several, certainly are relevant to the debate. We can't focus on just one provider, the National Arbitration Forum, to the exclusion of others. And what's interesting about the AAA consumer database or consumer claims is in our sample, there was a much higher proportion of claims brought by consumers. So if we really want to see how consumers do when they bring claims, we really need to look at not just the NAF, but also the AAA, which is what we're able to do. Then the sort of second point is the second phase of the study, that to really understand what our results mean from the first phase, we can't just look at the numbers and say 90% is bad, that's all we need to know. We need to have something to compare it to. And that's where in the second phase we're going to be looking at what courts do.
Do you have any methodological or other flaws that you would point out or opine related to public citizen study of the credit card arbitration in California?
Well, there certainly are some disputes, and I haven't studied the NAF in the same way that I've studied the American Arbitration Association, so I can't sort of talk about what exactly the practices are. Looking at the empirical results, there's a dispute about how you treat settlements, for example. I mean, the settlements benefit the consumer, so they should be seen as sort of a quote-unquote a win for the consumer. My main comment on the public citizen study is the interpretation of the data. And again, it's the same point. Even if businesses win 90+% of the time, that doesn't necessarily mean the process is unfair. And again, this is part of what we're going to be doing in the next phase of the study. But if you look at studies of small claims courts, which involve business debt collection, it looks amazingly like the way Public Citizen describes the NAF arbitration. Businesses almost always win. The consumers almost never show up. So this is not a problem with arbitration. And again, we may find out differently in the next phase, and so to that extent I reserve judgment. But from what I have seen so far, the problem is not with arbitration, that there may be issues with debt collection. I mean, if consumers in fact owe the money, it's not surprising they don't show up, for example. So I think a lot of this has to do with the type of claim rather than the process that's involved.
Mr. Chairman, the light's red. Thank you. Thank you.
Thank you, Mr. Franks. I now recognize the distinguished Vice Chairman from the Bay State, a former prosecutor, Mr. Delahunt.
Well, thank you, Mr. Chairman, for that rather generous introduction. I just have one question, and I apologize for being tardy. But we always hear how different approaches will save the consumer money. For example, arbitration will lower the litigation costs, and that is, as a result, of savings that's passed on to the consumer. Is there any data to support that, Mr. Arkush? Or is that just simply, you know, credit card industry speak?
If it's not nothing more than credit card industry speak, it's barely more. I mean, we've seen no data to support that claim, and in fact, there are plenty of data points that indicate the opposite. During the same period of time when the practice of forced arbitration proliferated throughout the credit card industry, the industry was raising fees, raising penalty interests, basically erecting all of the tricks and traps that industry now uses, that the full House of Representatives just acted to ban some of those practices this past week.
Professor Frankel?
I agree. The only thing that I would add is that in some way you could actually perceive it as raising costs on the consumer, because the consumer's credit card to some extent is less valuable the more time that they have to spend monitoring credit card companies because they don't have litigation as a forum. The more care that they have to take sort of reduces the value of their card. At the same time, credit card companies are charging the same price.
Professor Drahozal?
I would love to be able to do that study. It's really difficult to do. A way that I think about this issue is what would happen if credit card companies couldn't use arbitration. My prediction would be that prices would probably go up, interest rates would go up, and what that suggests to me is by using arbitration, implicitly the interest rates have gone down. And again, that's just sort of rough sense. I can't cite empirical studies. Because
Right, there's no data. And I remember during the hearings that we had on the so-called Bankruptcy Reform Act that we were told that an average family would save somewhere in the neighborhood of $400 a year if we passed that particular legislation. I haven't seen that kind of savings. Have you, Mr. Arkush?
No, we've seen nothing like it. And in fact, we get these types of claims repeatedly on not just bankruptcy issues, but any sort of so-called reform of the justice system. You frequently see claims that costs will be passed on to consumers, and they're never, as far as I can tell, they've never been borne out by the evidence. In fact, what we can really expect is restoring a robust system of accountability and liability for bad practices. That is what would reduce costs for consumers.
Mr. Donovan?
Congressman, let me build on that very point. We have to understand that the credit card industry, much like the subprime lending industry, is structured based upon a securitization product.
Right.
Almost all of the credit card receivables are securitized. To the extent that the investment community does not have confidence in that securitized product because people are using arbitration to hide their bad practices, that increases costs. It increases expenses. It increases credit throughout the United States. And the industry right now has used arbitration falsely, in a lie, to say costs will go down, when in fact costs will go up directly because of arbitration, because it hides material information from investors as well as from consumers. And there's no doubt that it hides material information. The whole idea of arbitration is to be secret so that nobody else catches on to the fact that you are committing bad practices.
I can remember this one statistic, and I think it occurred maybe in the late 80s, early 90s, where the federal funds rate went down to about 3%, and yet the average interest rate of a credit card was around 14%. It didn't go down. It never seems to go down. There never seems to be a savings for the consumer. Now, I can understand that, there's a marketplace, but when the marketplace is really the construct of the marketplace is at best an adhesion contract. And it doesn't just stop there, because it isn't just the individual consumer that's hurt. What we saw with subprime lending was that an entire global economy is put at risk. So if we don't address these issues from a public policy perspective, we put the free marketplace at risk. And anyone want to comment on that?
I just want to second that. I think that's exactly right. The reality of it is that the securitization product here is out there and it's trading now. To the extent that there are issuers who are engaged in bad practices and those things are disclosed, that securitization product then plummets. That requires banks to increase their reserves. That requires investors to buy credit default swaps, and that increases the direct cost that the banks, and we see this evidenced right now. Every one of the banks in the United States is now increasing their fees on credit card consumers. And they're doing that because they know that they have now been caught and that they have to increase their reserves. So arbitration will permit them to continue that bad practice in order for, and then when it finally comes to a fore, the securitizations will fall, and that will undermine another part of the credit market that we already saw undermined with the subprime lending market. So to support the free market system, one should outlaw arbitration.
Mr. Chairman, I thank you for the time, and I think that Mr. Donovan speaks with a sense of urgency. And I would hope that Mr. Johnson's bill might be considered for a markup in this particular subcommittee. With that, I yield back.
Thank you, Mr. Delahunt. I now recognize Mr. Coble from the state of North Carolina, whose national champions are being honored today on the House floor.
Thank you for that. Thank you for that unsolicited endorsement, Mr. Chairman. I appreciate that. The Jayhawker may not like that idea, though.
Yeah, we can talk about it afterwards.
Professor Drahozal, in my opening comment, I indicated some thought that maybe these arbitration matters are biased, either on the one hand to the benefit of the credit card companies, on the other hand to the benefit of the consumers. Any kind of comment on that?
Certainly, in the study that we did, I mean, a sort of common concern which has been expressed by various members on the panel and in the committee is the idea that arbitration may favor repeat businesses over non-repeat businesses. The study that, there's been a number of studies looking at that type of bias of the arbitration process. Typically, the studies we found is under some measures of sort of what are repeat businesses, there was no evidence, no statistically significant evidence of any sort of bias or any difference in result. With other measures, we found some evidence that repeat businesses fare better than non-repeat businesses, but the reason for that was that the repeat businesses were more sophisticated at handling disputes. That the evidence suggested that they tend to settle disputes more readily than non-repeat businesses, and they settle the strong claims against them, which means that what's left to litigate is the weaker claims, such that they then tend to do better. But it's not evidence of bias. Right. That it's really just evidence of different claims handling practices.
Thank you, sir. Professor Frankel, do you have any credible empirical or supported reason to believe that the state courts would be able to provide trials to the countless single plaintiff or class action plaintiffs who will show up on their doorsteps if the credit card and other consumer arbitration are eliminated? Any idea on that one way or the other?
Just want to make sure if I understand your question correctly. I think if consumers were allowed to go to court, there might be some class actions that proceed in state courts, and I think state courts are perfectly qualified state court judges are perfectly qualified to handle those class actions.
But I'm concerned about perhaps a plaintiff may not be entitled to a class action. He may not be able. Mr. Donovan, you want to weigh in on this either way?
Congressman, I think I understand your question, and that is if you have an individual case that's unique and it's not suitable for a class case, and there's thousands and thousands of those. The reality of it is those individual cases are almost always filed very quickly in small claims courts. Small claims courts handle them, and almost always the credit card issuers will settle those fairly quickly because they don't want to hire counsel to appear in small claims courts, and you get them resolved. By contrast, Congressman, with the National Arbitration Forum specified in the contract, the credit card companies uniformly refuse to settle. Why? Because they own that forum. That's why. That's why they put it in the contract. And they will fight those cases. So what happens is arbitration prevents settlement, prevents dispute resolution, and is in fact counterproductive, at least in the credit card contract. Now for class cases. You know, class cases are unique. You need a common question, a common uniform practice. They are particularly suitable in the credit card industry because it's almost all computer programmed. If it happens to one, it happens to all the credit card holders. And they are particularly suitable for payment processing problems. And I think I discussed one of the biggest things, and I'm sure your constituents have this problem, is they say, hey, I sent the payment in 2 weeks ago. They didn't credit it and they imposed a late fee on me. Well, what's happening is many times these credit card companies will change the P.O. box address where you're supposed to send the payment without telling anyone. And yet they impose the late payment still. Guess what? Anybody can complain. They could say, hey, look, you never told us that the P.O. box has been changed. You should credit me the late payment. They say, no, we're not crediting you the late payment. What do you need? You need a class action.
All right, my time's about to expire, Mr. Donovan. Let me extend this to Mr. Arkush. Mr. Arkush, generally the same question. If we eliminate mandatory binding arbitration, it seems to me that hordes of credit card customers will either not qualify for class action, as we just indicated, or not be able to afford counsel in their individual cases. And if I'm on the right track, these people may well be denied justice. What just public citizens say about this?
If we have a well-functioning small claims system, then people can go there without being able to afford counsel. Those same people that you're describing right now are getting no justice from forced arbitration. As I said, in 34,000 NAF cases, only 118 were brought by consumers. And the other thing that's important to realize, I think, here is that an important value that we get from being able to hold a company accountable in court is deterrence of bad practices. So one answer to what happens to the supposed flood of cases that would go into the civil courts is there would be fewer cases, there would be fewer disputes, because the companies would know that they could be held liable, and they would therefore act better to avoid liability.
Well, thank you, gentlemen. My time's expired. I yield back, Mr. Chairman.
Thank you. Thank you. Recognize the gentleman from Georgia, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman. Would like to hear some discussion about why a public proceeding, as opposed to a secret proceeding like you have in arbitration, why it's important for the freedoms that we hold dear under our Constitution. And also, the secrecy with respect to publishing a calendar so that the public, if it was not a secret proceeding, the public would be able to, just for the heck of it, decide I'm going to go, just like I'm going to go watch this civil trial in court. You cannot do the same thing in arbitration. And so I'd like for you all to talk on that. Also, the issue of mandatory rules procedurally. Also, the application of substantive law, the requirements or lack thereof in the secret arbitration process. And lastly, there's some who believe, including myself, that there's really no meaningful right to appeal any decision that is made by these arbitrators. And I will say that I'm a big fan of all forms of alternative dispute resolution, including mediation, including arbitration and any other processes that are available. But I just firmly believe that those selections should be made after the dispute arises and not before the dispute arises. So could I get some response, please?
Congressman, maybe I'm one of the few class action trial attorneys in the country, but I have had the honor of trying 4 class actions in the last 4 years, successfully each time. I can tell you this, the need to have, there's a psychological benefit that's a civic benefit as well to people believing that they obtained justice in a public way. And it happens not just for the plaintiff who may succeed, but it's also for the defendant and for the members of the jury. It's remarkable how empowered and important and good they feel about being part of the American fabric and the American community by participating in what is, in essence, the most American thing you could participate in, and that is a jury trial. Even if you lose, I think everyone comes out of a jury trial feeling that, well, look, I got a fair shake, I got a fair chance at justice, and this is, in essence, the American dream to present your case and to hear it and have it judged fairly in an American jury. With respect to how that contrasts with what has happened in arbitration, I think the proof is in the pudding that arbitration is so. Let me start with this, sir. I, too, believe in mediation and in arbitration. In fact, in most of our cases, we resolve them by using mediators from the American Arbitration Association, from JAMS, and those are retired judges, and they mediate and resolve the case. And we've used them. The difference is that we've decided to do so voluntarily. And each side approaches it with that idea, and they work out fine. We pay for it, and we think we've obtained justice. However, when that decision has been made in advance, all of my clients who have experienced that arbitration process have felt wronged. They felt disgusted and dirty by the process, because that forced arbitration is not American. That forced arbitration is a perversion of justice. And the proof is in the pudding. There are some instances in which courts have ordered cell phone companies and credit card companies to proceed in arbitration on a class-wide basis. And in fact, I've had several cases where a court has said, okay, you can go to arbitration, credit card company, defendant company, but you're going to go to arbitration with on a class-wide basis. In other words, the arbitrator will decide class certification. What has the defendant done in every one of those instances? No, 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 we waive our right to arbitration. Why? Because they know that that would be unfair to them, at least in their perception. So the whole goal of the pro-arbitration group is to do one thing, and that is to deny access to justice to American consumers. That's the only sole goal for pro-arbitration in consumer credit card contracts. Deny access to justice. And I just think that that's unpatriotic and wrong.
Thank you for your questions, Mr. Johnson. I now recognize the gentleman from California, Mr. Issa, 5 minutes.
Thank you, Mr. Chairman. I'll try to get the name right. Professor Drahozal?
Very good.
Last week, or actually, I guess it was last week at this point, we passed a reform bill out of the House overwhelmingly that included changes as to whether contracts could in fact be changed at will. Are you familiar with the legislation leaving the House?
I know of the legislation. I can't claim to be familiar with it.
Well, would you say that it was consistent with limitations that we can place on government, or as government on the private sector, to say that a contract that is to be changed must be changed with notice? That might have been a reasonable reform that would have responded to some of the other witnesses' statements that they made earlier, that this was an outrageous trend to sign binding arbitration, then have changes made without notice.
Certainly, to the extent the concern is that consumers don't know what's happening, a notice requirement would be a direct response to that, absolutely.
So looking at binding arbitration changes versus changes in what we allow to be in the contract, or fairness of contract in the first place, which would you prefer that we do, since it appears as though we have bills for both?
Yeah, given my role with the Earle Task Force, I'm not really in a position to sort of state a preference for what you all should do. Clearly, there are alternatives to getting rid of consumer arbitration, free dispute or otherwise, altogether. Changing notice provisions would be one. I know Senator Sessions has in the past introduced a bill that would set out various procedural requirements to be followed in a consumer arbitration. The other alternative, frankly, is that courts do actively police these. Particularly class arbitration waivers. It's sort of striking. Increasingly, courts are, when they are troubled by those sorts of clauses, stepping in and holding them unconscionable or otherwise unenforceable. So there are other. We're not sort of comparing a no or sort of anything goes system to getting rid of pre-dispute arbitration clauses. There are other sort of intermediate steps. And I guess the final thing just to mention briefly is that at least some arbitration providers, like the American Arbitration Association, which we focused on in our study, have their own private fairness standards, which are similar anyway to the ones that were in Senator Sessions' bills, which they do effectively apply.
Okay, thank you. Mr. Donovan, you proudly are a plaintiff's trial lawyer. So
yes.
I won't call you a hostile witness, but I'll say that you're predetermined to give certain answers and perhaps fair to give others. If in fact we were to eliminate the preemption, the federal preemption that we're dealing with, and allow the states to each have authority over credit cards, credit card disputes, would you generally favor that as a plaintiff's trial lawyer?
Well, you're talking to the lawyer who argued Smiley v. Citibank before the United States Supreme Court, and that was, of course, the case that said that contrary to 190 years of history, late fees will now be deemed interest because the OCC redefined late fees to be interest so as to preempt every state's law that limited late fees. No, I think with regard to credit card contracts, that it's appropriate to have a certain amount of uniformity under the Truth in Lending Act and certain centralized regulation. What is wrong is for the Federal Arbitration Act to basically nationalize 50 states' laws and preempt those laws when it comes to contractual doctrines like unconscionability. Right now, the problem, and this is the reason why Congress needs to act. You have certain states that have said, California and the Second Circuit in New York have said, well, these certain provisions of credit card arbitration clauses are unconscionable and they are unenforceable. You have other states that say, oh, we're sorry, we understand you have a very legitimate claim, madam, and you have a really good case, but and we don't care how unconscionable the clause is. Federal law.
Let me do one follow-up for Professor Frankel. Hypothetical, if we were to continue to allow states to reach different conclusions, and let's say that Visa or MasterCard or both chose not to do business in that state because it became punitive, even if competition came in and set up a one-state credit card system, would that be in the best interest of commerce to have essentially 49 states with one system, one with another, and no way for somebody to take their credit card and traverse the world?
I mean, honestly, I don't see a realistic prospect of that happening. I think that comes up in every situation, I think, where there's a request made to have federal preemption in legislation, that you can't have this patchwork of different state laws. But I think the risk of that is more myth than reality, and there's not really much empirical evidence in that respect. And I think.
Well, Mr. Chairman, if I could just broaden the question to anyone that wants to answer it. We have that in insurance, and insurance companies in many cases do not operate in California or other states. So if we assume for a moment that we mirror states' use in insurance, and that occurs, is that in the best interest from this side of the dais to allow to occur? And anyone that wants to answer on that.
Well, the only difference is in certain respects, Congressman, that does prevent systemic failures, as we saw with unregulated insurance companies like AIG and other activities that are not covered by state regulations. So in that respect, you will prevent systemic failures. In the credit card industry, I don't think it's realistic because we do have a fair amount of uniformity in terms of national banking, and that was a system that was set up after the Civil War, or in the midst of the Civil War. I think what needs to be prevented...
That was before I came to Congress.
Yeah, me too. But what needs to be prevented is this patchwork of arbitration decisions that you're now seeing, where some states are saying you cannot have arbitration for credit card contracts, and other states are saying that you can, so that the person in Texas gets no justice, and the person in California gets all the justice. And that's what's really happened right now. So Congress needs to step in.
Thank you. Thank you, Mr. Chairman.
Thank you, Mr. Issa. I now recognize the subcommittee chairman on criminal laws, the distinguished gentleman from Virginia, Mr. Scott.
Thank you, Mr. Chairman. My friend from California in his opening remarks mentioned centuries of jurisprudence suggesting that credit card issuers may have an absolute right to these binding arbitration agreements. Can somebody speak to the centuries of jurisprudence and how they apply to these claims, especially on adhesion contracts and antitrust, to demonstrate that we consistent with centuries of jurisprudence, do have the authority to regulate these contracts?
I hate to be hogging the floor, but it's my job, Congressman. Yes, I can speak to that. You're alluding to the Second Circuit's decision in Ross v. American Express, where that court has now allowed claims that the credit card industry has conspired to all include arbitration clauses in their agreements to go forward. The fact of the matter is that there's a lot of evidence of that, and because I saw the meetings, the lawyers for the credit card companies would get together at American Bar Association meetings and come to agreements on what language they would include in credit card contracts. And they would all use that same language in their arbitration clauses. And they all got together and said, oh, yeah, let's use this. This is good language. Now what they're trying to do is provide a fine print opt-out so that if the consumer receives this 25-page credit card agreement and doesn't opt out within 20 days after receiving it, that will be deemed consent to participate in arbitration. I mean, how silly is that? I mean, that's ridiculous. But that is what we're talking about, people who are paid hundreds of thousands of dollars and have earned Major League MBAs to see how they can get $30 additional out of each one of their cardholders because that brings $30 million to the bottom line this month. That's what the reality of it is, and that's what they do. They go to school for it, and they get trained for it, and that's what's happening. Now, in terms of 100 years or 200 years of jurisprudence, there's been 200 years of jurisprudence that has prohibited unfair, unconscionable, adhesive contracts. Those are contracts that are offered by the stronger party that take unfair advantage of a weaker party. The definition of an adhesive, unconscionable contract is a credit card contract with an arbitration clause. And I'm not the only one who says that. The California Supreme Court has said it. The Ninth Circuit Court of Appeals has said it. The only court that has not come out and directly said that is the United States Supreme Court. And the reason basically being is that until now, and it basically has not had to confront that issue because to the extent that it ever gets to that point, the credit card industry is wise enough to say, okay, we give up, we settle, here's your $105 million. So that's basically, but the problem is, Congressman, is that there are courts that will enforce these provisions. I mean, the Fifth Circuit enforces arbitration clauses. The Fourth Circuit enforces arbitration clauses. Until recently, the Third Circuit Court of Appeals, my own court in Philadelphia, enforced arbitration clauses that required people with foreclosure disputes to go both before an arbitrator while their home was being foreclosed upon by a court. And this split forum effect that people had to have, had to go in two different places at the same time to save their house. They were enforcing those. And the reason why we need this Congress to act is because that's wrong. It's just not right. It shouldn't happen. And the Arbitration Fairness Act should be passed. And I also want to say thank you to Congressman Johnson for pursuing this each year. I appreciate it.
So the point is, there's nothing inconsistent with centuries of jurisprudence. This bill is in no way inconsistent with centuries of jurisprudence.
Not at all.
Mr. Arkush, could you tell me the status of the case that's pending, the Komarova case that you mentioned in your statement? Where is it procedurally?
I believe, actually, that she has finally managed to get the award against her thrown out.
And that's court. That's is that a final decision? Do you know?
I believe so. Is anybody else clear?
And
I believe so.
That wouldn't surprise me because a ground for vacating an award is if you never agreed to arbitrate in the first place. So, but I don't know the case.
Thank you. And finally, Mr. Donovan, can you just make a quick statement? You've talked around this, but if a company comes up with a scheme where you rip off and defraud millions of people of a couple of dollars, what does a prohibition against a class action do to those claims?
Well, it basically prevents anybody from pursuing those claims. But, you know, the real question here, Congressman, is there's a fine line difference between, you know, a banker and a bank robber. A banker, if you take $1 from 1 million people, you're called a banker. But if you take 1 million from one bank, you're called a bank robber. And really, if in fact the 1 million people had as much clout as the banks have had, well, then those people would have outlawed this type of bank robbery.
Thank you, Mr. Scott. We're ready for our second round, and Mr. Franks.
Well, Mr. Chairman, I hardly know where to start. I've learned that a federal trial is the most American thing we can do, which, you know, sometimes I think I just want to step back here for a moment and ask myself, what are we really discussing here? And really, what we're discussing is the agreement on the part of credit card companies. They put in their agreement that because there are oftentimes people who don't pay their bills, that they put in the contract clause something that would require, as a part of receiving the credit card, that people subject themselves to agreed binding arbitration. My fear is that if we do away with that, we will end up hurting a lot of people where they just don't get credit. Because sometimes I think that my dear friends on the other side of the aisle feel like that somehow in Congress that we can repeal the laws of cause and effect in mathematics. And we saw that, I think, in the whole housing situation, where well-motivated, well-intentioned efforts to help people have homes put great pressure on banks to make subprime loans and things like this that simply couldn't withstand the test of reality. And we ended up, I think, having largely a government-incented economic meltdown because of it. And if we continue to put more and more and more load on the economy and the business and the private sector here that are trying to make things happen that are ultimately good for everyone, I think we're going to wake up some morning and realize that we're kind of under all of it. So I guess, Mr. Drahozal, I'll just go ahead and ask you, the bottom line of your study, that consumer arbitrations you examined were faster than litigation, cheaper than litigation, and essentially fair. Was that pretty much the bottom line of your study?
I can't say quite that strongly at this point without the second phase of the study, because as you sort of, the comparison we haven't done yet. Certainly we found evidence that costs to the consumer, the upfront costs actually are even lower than the low-cost arbitration rules provide for the AAA, that the hearings seemed to, the proceedings seemed to go at a fairly quick rate. Certainly no evidence of any repeat player bias, as I discussed before. So I guess I would agree with your statement with the caveat that we are not yet able to compare it to litigation, but that phase will be coming.
Okay. Well, do you think it would be helpful to do additional research then, and you're in the process of doing that, and you're...
Yeah, absolutely. Again, with sort of... I've been very pleased with the focus that the sort of committee and commentators have had on empirical work, and it's really, it seems to me, important to know what you're getting into before you do it. And as you noted, the work is in progress, and we will be doing it as quickly as we reasonably and sort of conscientiously can do.
Well, it's rather an obvious question, but when there are class actions on behalf of a group of consumers, isn't it true that most consumers receive a very, very, very small pittance amount for their part of the class action?
There certainly are class actions like that. I mean, that seems to me actually another area where more detailed knowledge would be useful, is to know exactly how often, sort of how much what consumers get and to what degree. For what it's worth, there was a recent study on employment arbitration, which obviously isn't directly applicable, but that compared what employees got in class actions to studies of what employees got in arbitration. And there's some issues with the study, but the study basically found that employees got more in arbitration than they did in class actions. So that type of study would certainly be very useful to do in the consumer setting.
Well, we've been told that there's just a fine line here between bankers and bank robbers this morning, and so I'm wondering who are the main what group are favored the most with these class actions? Who makes the most money out of it?
Well, that one I'm not in a position to say. I mean, there are obviously various parties who make money. The lawyers probably on both sides. Presumably the bankers do not make money through the class actions. And,
I wouldn't think so.
But again, that's not something I can answer sort of definitively because it's beyond my area of expertise.
Well, it sounds like in class actions the consumers don't make a lot of money, and the bankers don't make a lot of money. But it seems that it's pretty clear that the lawyers make a great deal of money. And I'm being, a little facetious here, but I felt like that there had to be some response to some of the comments made here. So I guess the bottom line is, Mr. Chairman, is that when we inject ourselves into the private market and say that you cannot make these kinds of agreements, because that's really what we're doing here. There's nothing that forces arbitration on anyone that they don't agree to say, yes, I agree that I will subject myself to arbitration. And to take that tool away from business is not only to clog our courts, but to make credit harder and more difficult to make available for the very people who need it most. And with that, I yield back.
Thank you, sir. Professor Drahozal, do you see a virtue in class action suits in general?
Certainly, in theory, they're a very sensible way to resolve disputes, that you aggregate small disputes.
And do they serve, does the class action attorney serve somewhat as a private attorney general in terms of showing up some defect in the business, the contract, or the relationship, which could then be cured by the imposition of a large class action judgment?
Well, and again, that certainly is the theory behind class actions, as well as attorneys' fee shifting statutes and so forth. There's various ways that the justice system has structured things to try to give private parties incentives.
So is there a way that you can see where you could have arbitration for smaller cases, individual cases, but still permit class action suits so that when there is a uniform, not an individual, but a uniform policy or activity that's taking place, such as the changing the address on the barcode, that justice could be had through the civil courts?
It seems there's two possibilities. I mean, one is a number of courts, as I noted earlier, have in fact refused to enforce class arbitration waivers, which has had the effect of the cases proceeding as class actions. I mean, that's under the current structure of the Federal Arbitration Act, a permitted approach, and state courts have increasingly been doing that. A second alternative would be arbitration on a class basis, which I think the AAA has several hundred cases now that it is administering on a class-wide basis. So there are ways in which arbitration can coexist with class relief.
Professor Frankel, is there a way to have a bifurcated system where you've got certain claims can go to class actions and jury trials and others might be still limited to arbitration?
I mean, I think that's certainly preferable to the system that we have now. Just to build on what Professor Drahozal said in terms of courts that are refusing to enforce class action bans, I don't think that is an adequate substitute, because what is happening now is that credit card companies will write in their contracts to apply that their contracts must be governed by the laws of states that will enforce class action bans. So they're getting around that by the way that they draft their contracts. So I don't think that is going to be an adequate substitute. I think, how you deal with there are still, I think, potential problems that some of the other witnesses have mentioned about individual cases, but I think removing sort of the class action types of cases and either saying those can proceed in a class-wide arbitration or can proceed in class actions is certainly a benefit. But you'd have to make sure that the procedural protections that occur in class actions also.
Thank you. Mr. Donovan, as you heard, as I heard, the statement that was repeated, I think, by quite a few Congress people, plaintiff's class action attorney, as if, there was I guess it's redundant. But I guess you could be a defense class action attorney. I don't know. But in your case where the credit card company was changing the address, now you were capable of going to court because that jurisdiction or that circuit does not recognize the ban. Is that correct?
Several of these cases pre-existed the imposition of prohibitions in arbitration or pre-existed arbitration clauses in the credit card contracts. The credit card contracts basically started having arbitration clauses installed in them in about 2002. That's when the industry met at an ABA meeting and decided, let's put arbitration clauses in all these contracts in order to destroy these claims that the industry was confronting. So Providian predates that. The Rossman v. Fleet case, where they said they promised a no annual fee, but then they imposed an annual fee on everybody within 3 months. A lot of those cases predated arbitration. The subsequent cases are cases that emanate out of California, where the California courts have found arbitration clauses that prohibit class actions to be unconscionable. So those proceed that way.
In your particular case, what jurisdiction were you in?
Well, the Fleet case, we were in Philadelphia. We were in the federal court in Philadelphia and the Third Circuit Court of Appeals.
So that was a pre-existing situation?
Correct.
What was their defense? Did they say it was a mistake, or did they just say we screwed people?
Well, in the Providian matter, was you can't bring any state law claims because they're all preempted by federal law, and federal law, the Truth in Lending Act, allows us to do this. And, oh, by the way, we're allowed to charge these late fees because they're permitted by the Truth in Lending Act. They basically had a preemption defense to that claim.
Now, I'm talking about the one where they changed the address on the barcode.
The address barcode, we didn't get to hear the defense because once we pointed that out and the witness who testified about it, they settled.
Never did they claim it was an accident?
No, they never claimed it was an accident. In fact, there was a memo saying that, well, if we have everything sent to this, we'll increase revenues by this amount.
And under the system we have today, could you bring that action under a fraud charge and get around this, or would you be barred under the Arbitration Act?
I don't think you could bring it as a fraud charge per se, because fraud charges are hard to get certified as a class action. What you bring it as is a violation of the Truth in Lending Act. You bring it as a breach of contract. You bring it as a unfair, deceptive practice, because there really wasn't a representation, a promise that said, oh, by the way, this barcode says it's going to the right address, because nobody can read barcodes. So you can't really have a fraud claim. But you could have an omission claim, and you could have that certified. Could you bring that in an arbitration case? What it took was, it actually took a fair amount of forensic analysis. We had to spend some money to find out that's what was happening, because we couldn't figure out, why are people sending these things 2 weeks in advance, but the bank is saying we didn't get them? And we finally figured it out. And then finally they came to clean that, oh yeah, we intentionally did that. So, and then changing, the Fleet case, what Fleet said was, oh yeah, when we sent out the promotional rate that said no annual fee, 3 weeks later the Federal Reserve increased interest rates. So therefore we have to put the annual fee on, because otherwise our revenues won't be enough. And they sent out a letter saying, because the Federal Reserve increased interest rates, we're going to impose an annual fee. And the court said, no annual fee means at least no fee for the first year. Otherwise, it's a breach of contract. So you can, now if there was an arbitration clause, we were, Ballard Spahr was defense counsel, very good firm, honorable, decent, defended the case, and they came up with a lot of good arguments, preemption and everything. One individual person could not beat those lawyers. They're good lawyers. If they didn't have other counsel, they would have lost. So you had to pursue that as a class case. And this happens, look, the reality of it is Citibank, Bank of America, Wells, they hire the best, brightest lawyers in the nation, included among them Sidley and Austin. And, the Sidley and Austin firm defends the tax evasion, the tax shelter cases, where everybody said they got hit by the IRS because of tax shelters that were disallowed, and they bring claims against the accountants and the lawyers. Well, the first thing that the defendants do in those cases is say, oh, arbitration. Oh, yeah, we know we didn't sign the arbitration clause, but a third party that we are related to, by second cousin status signed one, so we are subject to that arbitration clause. And that's what the defendants do. So
thank you, sir.
This has to be passed. The Arbitration Fairness Act has to be passed.
Thank you, Mr. Delahunt.
Yes, thank you, Mr. Chairman. Would you if there's a provision in a credit card contract that says at the end of the terms and conditions that the credit card company or issuer can change the terms at any time they want, and that all of the terms and conditions that were enumerated previously, would that fit the definition of an adhesion contract?
Well, that's what the credit card contracts are now. Yes, they are adhesion contracts because they're take it or leave it contracts. You either take it
Right.
or you leave it. That's what the adhesive thing is. The thing that's different about the credit card contract, and they try to justify this on because it's a revolving line of credit, is that they can change any term, any time, for any reason. So if you're counting on having this money at 6% interest for a year, because that's when the date of your expiration on your card is.
Mr. Donovan, my point is, and I obviously agree with you and I understand that, but to call that a contract is, flattery taken to a different level. I mean, that's just, that's a joke. That's what it really is. Of course, it's an adhesion contract. And when I hear that, well, you have contractual obligations, that's not a contract. It just isn't a contract. And in terms of class actions, one aspect of the rationale for class action suits is to serve as a deterrent to bad practices. In other words, it isn't just simply about compensating or redressing those members of the class, but it's preventing bad behavior post the ruling, the decision in the case. Am I stating it accurately, Mr. Donovan?
The way I like to look at it, Your Honors, because we always talk about this from the perspective of consumers or homeowners or anything, is it's a moral hazard. This device imposes a moral hazard on credit card companies to don't do this, or else you're going to increase the cost on you alone. So it imposes a moral hazard on the whole thing, so others who are observing it won't do that too. The benefit is that helps investors to have confidence to buy these securities that are backing up the credit card product. And the moral hazard is then presented on the bad actor alone, pinpointed, and the others get to observe and prevent, and they're deterred from engaging in the same bad practice.
Thank you. That's all I have.
Mr. Johnson, do you have any further questions?
Not at this time, Mr. Chairman. I'd be happy to yield the balance of my time to either one of my colleagues here, Mr. Delahunt, or, of course, Mr. Scott.
Thank you, sir. Mr. Scott, you're recognized with the balance of Mr. Johnson's time.
Thank you, Mr. Chairman. I don't have any questions, but I would just thank the panel, particularly Mr. Donovan, for pointing out that adhesion contracts do not have to be enforced, and that is absolutely consistent with centuries of jurisprudence. And furthermore, if you conspire with others to put the same provisions in a contract, that violates antitrust law. So that what we're doing with these bills, what we're doing is absolutely consistent with centuries of jurisprudence. What the bills would do would be to add some consistency, so regardless of what state you're in, you can benefit from reasonable consumer law. And I'll yield back.
Thank you, Mr. Scott. I don't know if we need another round or not, but Mr. Franks, do you have any other further questions? If not, I think we've had a very healthy discussion, and I think it's been the best attendance we've had at this subcommittee. I want to thank the witnesses and the issue for eliciting that. We thought we had to call the fire marshal at one point, but too many members up here. but we didn't. So I'd like to thank you all for your testimony and your attractiveness. Without objection, members have 5 legislative days to submit any additional written questions, which we will forward to the witnesses and ask you to answer as promptly as you may. They'll be made part of the record. Without objection, the record will remain open for 5 legislative days for the submission of any other additional materials. Thank everyone for their time and patience. This hearing of the Subcommittee on Commercial and Administrative Law is hereby adjourned.